Good morning again. Our second case of the OA calendar is Puckett versus State of Florida, case number 2024-2760. Mr. Ufferman from Tallahassee, you may proceed, and before you start, if you would like to reserve any time for rebuttal, please let us know now.
Very good. Good morning. Yes, I would like to reserve 5 minutes of my time for rebuttal.
Thank you, Mr. Ufferman. You may proceed.
May it please the Court. Michael Ufferman on behalf of Mr. Puckett. There's one issue in this case, and that is whether or not the state proved a crime pursuant to the statute that was charged in this case, which is 815.04. And I submit that the evidence that the state presented as a matter of fact and as a matter of law does not establish that my client committed a crime under that statute. The question becomes, did my client, quote, without authorization, modify or render unavailable data? And the answer is clear-cut from this record that he always had authorization.
But isn't authorization a little bit different than, he may have had authorization to access the computer system, but did he have authorization to render the data unavailable?
Yes.
My understanding from the testimony was that he accessed the machines, erased some of the data which caused the machines not to work. So why is that not a question for the jury to determine at that point then whether he rendered the data unavailable when you're talking about a judgment of acquittal argument?
Yes, of course, and I acknowledge that the standard is in the light most favorable to the state, but even in the light most favorable to the state, my client at all times had authorization to access these computers.
But again, authorization, access, I wouldn't disagree he had access to these computers, but did he have authorization to render the data unavailable? And I think the state had pointed this out, maybe it's in your brief also. You've got 815.04, but then you've got 815.06. If it's 815.06, you're probably winning on that pretty clearly. But isn't 815.06 a different statute than 815.04? And that's what the state charged him under, correct?
I think it's the opposite, Your Honor. And let me answer both
Okay,
of
go
those
ahead.
questions.
Yeah, sure.
I think the first question you asked is, did he have access or authorization to render data unavailable or modify data? The answer to that question is unequivocally yes. He was brought in as an engineer to develop a source code and to put that source code onto these machines and to update those machines. Every time he went in to update those machines, he is modifying data. Every time he goes in, just as any of us, when whatever type of cell phone you might have, whether it's an iPhone or something else, when the phone says, oh, there's going to be an update to your phone tonight, you know for a good period, depending on how long it takes, some of them take a good 30 or 45 minutes, you can't access your phone because an update is being conducted on that phone. That was his job. He was literally, and this is, let me refer to page 235 of the record. This is Mr. Honeysuckle's testimony. He's one of the brothers who's equity owner in Tended Bar. This is at the bottom on line 19. Question. And as a product of his job, in addition to being able to freely access everything he could deal with remotely, he actually had like mock-ups, computers, like Tended Bar equipment on his end, correct? Answer, he did. He worked remotely. He wasn't even located in Jacksonville. He was located in Tennessee. He was given the task as the engineer that was hired by this company to go in, develop the source code, update the source code, modify the source code when it needed to be updated or modified. And to do so, he had to access the data on those machines. And in doing so, he would, from time to time, make the data temporarily unavailable. So going back to the second question, I think if my client had been charged under the current version, or the version that was in effect at the time, the 2021 version of 815.06, that deals with what the 4th DCA was addressing in the Rodriguez opinion about exceeding authority. So in Rodriguez, this is before either statute had changed, there was a question about, oh, this person had the ability to access machines or devices, but maybe went beyond what the authority would have allowed. And the 4th DCA went on to say, we note federal statutes have addressed this situation by adding, quote, exceeding authorized access to the list of prescribed conduct. And they cite to federal statutes which define exceeds authorized access as accessing a computer with authorization, and access as accessing a computer, such access to obtain or alter information in the computer that the accessor is not entitled to obtain. So there may be initial authorization, but then they're doing something that exceeds that authorization. So arguably, if my client had been charged under 815.06, well, so let me back up there. Rodriguez was decided in 2007. At that time, neither of these two statutes contained any language about exceeding authorization. But the legislature did, in fact, amend 815.06, and in 2021, the version that was in effect at the time of the offense in this case, now 815.06 says without authorization or exceeding authorization.
Well, let me ask you, was there testimony from the owners that he did not have authority to do what he did to render data unavailable? Was there at least testimony by them? I thought there was testimony in the record. One of the machines had its program erased while another was 50% erased. He didn't have authority to do that. So isn't that a question for the jury at that point to determine?
And I think that's exactly why in Rodriguez, the 4th DCA reversed and said, the question is there authorization? And either there is or there is not. And if there is, then the defendant can't be convicted under the statute. So let me contrast this to like...
Was Rodriguez dealing with 815.04 or 815.06?
It was dealing with 815.06, but I think they're similar concepts. And I think the big difference is Rodriguez suggested this might be different if the Florida statute mirrored the federal statute and added a clause without authorization or if authorization exceeding that authorization. Well, we know the legislature went ahead and amended 815.06 to do just what the 4th DCA suggested, but 815.04 has never been amended. So the only question under 815.04 is, does he have the authorization? So let me compare this to a hacker, for instance. A hacker who was never given authorization, if the hacker had hacked into these machines and erased data on the machines or took away a password, clearly that would be a proper focus of 815.04, someone who could be convicted, because the state could easily prove that that person didn't ever have authorization. My client at all times, and I know the court's familiar with the timeline, but the controversy arose on the morning of September 15th, 2021. And then my client's last access to the machines was between 10:27 a.m. and 10:30 a.m., but then it wasn't until 11 a.m., between 11 a.m. and 2 p.m., after my client's last access into the computers, that my client was terminated. So clearly, if my client, after being terminated, had access to the computers, he would not have had authorization.
Well, so again, if he has authorization, so I'm not disagreeing with that. It says a person who willfully, knowingly, and without authorization. Okay, but then the statute goes on to say introduces a computer contaminant or modifies or renders unavailable data. So it's two parts to that. It's also rendering data unavailable, which was the testimony of that's what he did. So why isn't that a question for the jury to decide whether he rendered the data unavailable or not?
My client had authorization to do that. He did it all the time. Every time he put an update on the machines.
Except the owners said that he didn't, correct, in this case?
For this, they were trying to say that he didn't have, that an update, since we were getting so close to the start of the Jaguar season, they wanted updates to be done in person and not remotely. That may be true of September of 2021. Prior to that, my client had been authorized to access every one of these machines remotely. I just read you a quote that specifically said that. So they may have tried to limit his authorization, but again, that goes to exactly what the 4th DCA is talking about in the Rodriguez case. There's a difference between without authorization or exceeding authorization. If without authorization means no authorization at all. Exceeding authorization means you have authorization, but you're doing something that exceeds that authorization. That's literally the holding in Rodriguez, why they granted relief. They said that the person had access and authorization. It might be different if the statute had said exceeding authorization, but the statute doesn't say that, and therefore, because it was clear in that case the defendant did in fact have authorization, the 4th DCA said a JOA had to be granted. And again, the legislature responded and added exceeding authorization to 815.06. If they had done the same for 815.04, my client would be guilty, because the state's theory would have been, yes, he may have had authorization to go into these machines at any time, to add source codes, to modify source codes, and when doing so, that's going to render data unavailable. However, he did not. His authority did not allow him to do it remotely, at least at this period in time. His authority may not have allowed him to actually erase some material.
So does his motive matter as to why he rendered this data unavailable to
Not
you?
for purposes of determining the plain language of the statute.
Because I think he made comments like time is ticking, you have 45 minutes to do something. I mean, it almost seemed like he was holding the company hostage.
Again, if the statute said, or exceeding authorization, as 815.06 does now say, then the other question would be, is it willful? And I think the state would have an easy time showing that based on those statements. But the question is, under the plain, strict reading of 815.04, it says, and without authorization. That means no authorization. There could be an exceeding authorization aspect of this, as suggested by the 4th, and as the legislature has now added to 815.06, which I agree would allow the state to get a conviction. The state could have charged a crime under 815.06, and the state could have gotten a conviction. But as 815.04 read at the time of this alleged offense in September of 2021, the state was required to prove that my client was, quote, without authorization. He had no authorization. He clearly had authorization. He had authorization. He was hired specifically for the purpose of creating the source code, going into the machines, modifying the source codes within the machines. That's one of the elements of the offense. Modify or render unavailable data. Again, every time you update a machine, you are rendering unavailable the data in that machine during the time that that update is occurring. The state simply chose the wrong statute. This court could do the same that the 4th DCA in Rodriguez said, that look, strictly construing the statute, we can't find that the evidence shows that Mr. Puckett didn't have authorization. However, the legislature may want to consider, just as the federal, just as Congress has done and just as the legislature has already done in 815.06, adding an exceeding authorization clause to this statute. That would cover this conduct, but as written, strictly construed, the state is unable to prove that my client...
authorization to render data unavailable, how would you exceed that authorization?
If they told him that at no time are you allowed to erase data. Mm-hmm. If they told him at no time are you allowed to make it so the data would be unavailable at any time, so the two owners can always access it. If they would have given that type of an instruction, that would have been a contingency on
Now
his
you're talking
authorization.
about access again. I think the statute talks about authorization to introduce the contaminant or render data unavailable. That's the authorization. So if you have authorization to render data unavailable, how would you exceed that authorization? I'm just trying to understand how, because your argument is based heavily on the word exceed. I'm just trying to understand how that would work.
They could have said, Mr. Puckett, you have authorization to modify data or render unavailable data under these conditions. The modifying has to be that when you go in and update the source code, if we've given you permission to do so, then you can update the source codes on the machines. As far as rendering data unavailable, we recognize that when you go into the machines to conduct an update for that period of time, that's going to render data unavailable. But other than that, at no other time are we authorizing you to render data unavailable. If they would have given such conditions like that, and maybe they did give conditions like that, that would be exceeding authorization if he proceeded to do so. But you cannot say that he did not have authorization to modify data. That's literally what his job was. And you can't say that he didn't have authorization to render
Time
data.
matter? I mean, could they say, well, you're authorized to do that today, but you're not authorized to do it tomorrow?
Yes, that would be, I think that'd be a closer call. There's nothing that was said here along those lines, but again, that may also fall into exceeding authorization. That if he's authorized to act to modify data on a Saturday, but not authorized to modify data on a Sunday, and he did go in on a Sunday, he's authorized to modify data. He's just exceeding the authorization by accessing it on a Sunday. Again, I think that's why it's so important. And again, the 4th DCA recognized it, and the legislature clearly recognized it when they amended the former version that was in effect when Rodriguez was decided to the current version, which specifically says, and without authorization or exceeding authorization. So without authorization simply means no authorization. And again, doesn't render the statute meaningless. That's going to apply to 99% of the people that are subject to this statute, which are hackers, people who have no authorization to go in and do anything with the data. But if they want to cover people who have authorization but potentially exceed it, then they need to add that clause. Otherwise, especially, again, reading these statutes in peri materia, knowing that the legislature knows how to add that clause to 815.06, but didn't add that clause to 815.04, strictly construing 815.04, the state's required to prove that my client was without authorization. And he wasn't. He had authorization up until the termination email at 11 a.m., and he did nothing after 11 a.m. on September 15th, 2021. I see I have about 4 minutes remaining in rebuttal. I will reserve the rest of my time for rebuttal. Thank you.
Thank you, Mr. Ufferman. For the state.
May it please the court? My name is Christina Piotrowski, and I represent the state of Florida. So in this case, the appellant was charged under Section 815.04, subsection 1, which provides that a person who willfully, knowingly, and without authorization introduces a computer contaminant or modifies or renders unavailable data, programs, or supporting documentation residing or existing internal or external to a computer system, computer network, or electronic device commits an offense against intellectual property.
What do you do with what we just heard from Mr. Ufferman, that his client did have authorization to modify data? You would agree he did have authorization to modify data?
I can agree that he had authorization to access the computer or the computer system, but if we look at the plain text meaning of the statute...
That wasn't my question. Thank you for... and maybe you disagree. Did he have authorization to modify data?
He did not have authorization to modify the data. He had authorization to access the computer, which is what I believe appellant focuses on, which is under 815.06, and discusses accessing the actual computer.
Didn't he modify data? I mean,
or render the data unavailable. My apologies.
Yeah, but yes, data. But regardless, aren't there examples in this record where he did modify data with authorization or not? I'm just asking.
So he would have been authorized. It was his job to go in there and possibly do the updates. But we have evidence from the president of the company that he was not authorized to modify and render any data unavailable on the tended bar machines on this date that is in question.
So is there a difference between, as Judge Jay was asking you about, modifying by making an update versus making the data unavailable?
I would say so. What matters is whether or not he was authorized to make that update. An update may make data unavailable, but the question is, did he have the authorization to modify and render any of that data unavailable? And in this case, at this time, he did not have that authorization.
Was there testimony that he did not at this time? Was
Yes,
there testimony
there was from the president of the company. He specifically said that all updates would be done with someone in front of the machine. No one was in front of the machines at this time. After that initial phone call when he said, make me CTO or else, they immediately sent people to the stadium to unplug those machines. And as you had stated, one had got fully erased, one was half erased. So I would say that the state did put forth sufficient evidence to show that there was not authorization, and it would have been proper for the jury to have decided that question. So appellant is interpreting the use of without authorization to exclude him pretty much because he did not, or because he had authorized access. And access, which is defined in the chapter, is not included in section 815.04 at all. And no other language in the section supports an interpretation that without authorization does not apply to those who have authorized access. And that's because this section is not about access, but the sabotage of a computer system, whether there was authorized access or not.
So he owned shares in the company, correct?
I'm unsure of that.
So I thought part of his agreement was
believe
that he
he
owned
was-
shares. So was he an owner of the company or an employee? Was he a part owner of the
Appellant
company?
was an employee of
was
the
an
company,
employee?
yes.
Okay.
And he had a contract. I believe he wanted shares of the company, and he wanted.
He was paid not with cash, but he was paid with equity. He owned shares in the company.
I'm unsure of that.
That's what the record says.
I do know that he was employed by the company and that he did have a contract. I don't specifically
So
know how he was paid.
he had an employment contract.
Yes,
Okay.
Your Honor. So the state would
So
argue.
was there any dispute at trial whether or not he was actually an owner of the company? So I just wondered, can an owner, sabotage his own property? I guess that was the
I don't believe
question.
there's any dispute of that. The president of the company,
So there's no dispute that he was actually employed with it?
he was
an
just employed by the
employee.
company. He had a contract. He was hired, brought on so that he could write the source code for the tended bar machines. And
This is a corporation, right? So
Yes,
you wouldn't say, I assume that you would not argue that if I go buy one share of Disney, that I can hack into the Disney computer system and delete stuff,
correct, yes.
right?
Yes, because like I said, he was authorized to access the computer. He may have been authorized to do updates. As you have law clerks who may be authorized to access your opinions, perhaps edit them, but that does not mean that they're authorized to delete the entirety of that opinion right before it is published. The state would also argue that, whether you are exceeding authorization or without authorization, you just do not have authorization. Whether you've exceeded it or not, you've gone into an area where you just do not have the authorization. And 815.04 does not discuss accessing a computer in Rodriguez. That case is under 815.06, and what they discuss, and also in Willoughby, which is in the briefs, is 815.06, and there was authorization, or that the state could not prove that they were not authorized to access the computer system, which usually when you are employed, you will get that authorized access to the computer system. But that does not mean that you can go beyond that, and that you can exceed it or do something that you simply are not authorized to do under 815.04. So that access is not included in that section because that is not what 815.04 is about. He could have been brought under 815.04, the charges could have been brought under 815.04 or 815.06. It does not have to be one or the other. But the charges were brought under 815.04, and so appellant's reliance on the access and the authority issues under 815.06 is misplaced. So the state would argue that under 815.04, the language without authorization refers to the lack of authorization to the actions that are directly listed after it in the statute. And the facts of this case are pretty undisputed. So while he may have been allowed that access to the computer, he was not authorized to render unavailable data on the tended bar machines. And the state provided legally sufficient evidence to support that, and it properly went before the jury to decide. The state would ask this court to affirm. Is there any other questions? Thank you.
Thank you. Rebuttal?
Thank you. May it please the court. Respectfully, I think the state gave an example that helps prove my point about perhaps a law clerk having access to this court's database to be able to draft summaries, draft opinions, but wouldn't have the ability to delete those opinions. That's a classic example of the law clerk has authorization to go into the court's server and modify data. Clearly, when the law clerk would go in and update a summary or work on an opinion. But the state says the law clerk wouldn't have the ability to delete all the court's opinions.
What if we didn't give them authorization to do that? To
Well,
delete our
okay, it
opinions?
assumes, yeah. Well, the question is, does the law clerk have authorization?
She might have, the law clerk might have access to our system, but doesn't have authorization to delete our opinions.
Does the law clerk have authorization to modify data? Because that's the language in the statute, right?
Well,
And-
that's also renders unavailable.
and renders unavailable, so it's not a perfect analogy, but going with at least the modifying data aspect of it, which I think could be a good analogy, the answer to that question would be the law clerk would have authority to modify data. But perhaps the court says in the contract or in some type of written or oral instruction, however, you can never go in and delete existing opinions or delete drafts of opinions. Then if the law clerk proceeded to do that, the law clerk would be exceeding the authority otherwise granted to the law clerk. And again, under the 815.06, because the legislature's added that language, that could be a crime. But under the 815.04, it has to be without authorization in that example, which is very similar to Rodriguez, very similar to the first example in Willoughby. That, because authorization existed, there can be no crime. So in this case, the state also conceded, ultimately, that my client did have authorization to update the source codes on the computers. Page 205 and 206 of the record confirms that. That's what my client was hired for. He's the engineer computer guy. The other two are the ones that are going to go out into the public and sell the product and come up with the idea, but they needed my guy to be the computer guy to do all the work. He didn't even live in Jacksonville. Everything.
Can you just address the core argument that 06 deals with authorized or unauthorized access or access that exceeds authorization, whereas 04 doesn't deal with access at all. It deals with authorization to delete.
That's true, but the question still has to be, does the defendant or the charged suspect have authorization to modify data, to render data unavailable? In this case, the record shows my client did. He was allowed, actually his job was to put those updates on the machines. In doing so, that's going to
Not
render...
at this time.
Oh, no, but...
Was there evidence to suggest that he was not supposed to be doing it at this time?
There was evidence that there was no scheduled update on the day of the incident.
Right.
So he exceeded his authorization by doing an update
But
that
04
day.
doesn't say exceeded.
But just right.
If he was charged with simply accessing it, then 06 would be more in play, right?
But there has to be a difference between without authorization and exceeding authorization. Without authorization means you have no authorization at all. Exceeding authorization means you have authorization, but there's certain things you can't do. What we're talking about falls into the latter category, which is why in Rodriguez, the 4th DCA said the legislature should amend the statute. It could cover this conduct. And for those reasons, I'd ask this court to strictly construe the statute and therefore reverse for a judgment of acquittal. Thank you.
Thank you. Thank you both. Given the fact that we have finished our second OA, our last OA of the day, we'll be in recess. Thank you both.
All rise.